Hello, my name is Derek Hilding. I'm an attorney with the DNR Division of Lands and Minerals. I'm presenting Section 2 covering legal information. Section Overview. In the presentation today, I'm going to briefly discuss legal requirements for DNR utility licenses, possible constraints on DNR's ability to grant a license, limited situations where a DNR utility license may not be needed, signature authority, how the application you submit becomes part of the terms and conditions of the license, and finally, I'll wrap up with a few closing remarks. Legal requirements for DNR utility licenses. As an executive branch agency, DNR's role is to implement and enforce laws that have been enacted by the state legislature. The legislature has enacted a framework that governs the DNR's issuance of utility crossing licenses. This is found in Minnesota Statute Section 84.415, and we have a little snippet of that statute here on this slide. I'm going to refer to this statute section as the utility license law for the rest of my presentation. If you are interested in reviewing the utility license law in full, it can be found online at the Minnesota Revisor of Statutes website. The utility license law sets the broad parameters of DNR's utility license program. As directed by the utility license law, DNR has promulgated administrative rules that contain additional standards and criteria for utility crossing licenses. The administrative rules are found in Minnesota Administrative Rules, Chapter 6135, which are also available on the Minnesota Revisor of Statutes website. Of note, the administrative rules set forth the crossing fee amounts and the design standards for utility crossings of state land and public waters. The overarching requirement of both the utility license law and the administrative rules is for utility crossings to have a minimum adverse impact on the environment. It is also important to keep in mind that the utility license law does not require DNR to grant utility licenses in any particular instance. The law says the DNR may grant utility licenses. As will be discussed in more detail in other portions of this presentation, there can be reasons why DNR would decide not to issue or could not issue a utility license in a particular situation. Examples include if existing land uses are not compatible or resource review has raised a concern with issuing a license in a particular area. Possible constraints. This is getting at things that could affect DNR's ability to grant a utility license in a particular situation, or the terms and conditions of a license that would be needed in a particular situation. If DNR is going to issue a utility license, the crossing cannot unduly interfere with existing use of state land. Additional coordination may be needed. Examples would include if a state land at issue is subject to existing state mineral leases, easements, leases, other utility licenses, etc. There may also be reasons why DNR just cannot issue a utility license, such as a deed restriction from when DNR acquired the property, or a funding restriction imposed by the funding source DNR used to acquire the property. Limited situations where a DNR utility license may not be needed. This slide discusses the limited situations, and I want to emphasize the word limited, where a company may not need a utility license from DNR. A utility company may have legal rights to install or operate a utility that existed prior to DNR owning a particular parcel of land. This could be from an existing utility easement granted by a prior landowner. In that situation, it would be important to review the language in the easement document to determine the rights that were granted and the terms and conditions of the utility use. Other pre-existing rights could include prescriptive rights. Prescriptive rights are a complex legal concept that I'm certainly not going to fully cover today, but they could potentially arise if a utility has been operated on a property without permission from the landowner for a long period of time before DNR acquired the property. There are certain legal requirements that need to be met to establish a valid prescriptive right. It is important to note that prescriptive rights would only apply on lands that DNR acquired some point along the way, and they would need to be based on the time prior to the state's ownership. Minnesota law is clear that prescriptive rights cannot be established against state property. So this means that prescriptive rights cannot exist on lands DNR has owned since statehood, such as school trust lands that were granted by the federal government. And prescriptive claims cannot arise on utilities installed on state lands without a license. Signature authority. Changing gears a little bit, I also want to briefly discuss signature authority. Getting into the details of this topic can be complicated and there's nuance, so we're not going to do a deep dive on this by any means. But DNR does encounter issues with this, so we want to put it on your radar. As would be the case with signing any legal document, in general, DNR needs to ensure the person signing the utility license on behalf of the company has the proper legal authority to bind the company to the license requirements and obligations. Again, I won't get into the particulars because the details will depend on whether the company is a corporation, limited liability company, limited liability partnership, cooperative, municipality, etc. But if the person that will be signing the license does not have clear apparent authority under Minnesota law, DNR will likely require additional documentation to evidence signature authority, such as a company board resolution or delegation of authority document. If you have questions on this, please consult with your company's legal counsel. Application is part of license. On this slide, I have a note about a pretty unique feature of DNR's utility licenses. The application a company submits for the license, if DNR approves it, becomes a binding part of the license itself. For example, the company is required to comply with the crossing location and installation method described in the approved application. I want to mention this today because it's a reason to make sure applicants are submitting good, clear applications. Also, applicants should be sure that the application contains crossing specifications the company can actually achieve. Disclaimer. I hope you found this really brief legal overview of DNR's utility license program helpful. Please keep in mind that this presentation is not legal advice. DNR attorneys like me do not represent you. Our job is to look out for the state's interests in these transactions and to ensure the legal requirements are being met. If you have legal questions that arise during the application process, license signature process, or at any other step, you'll need to consult with your own legal counsel. But for non-legal questions, feel free to reach out to DNR Lands and Minerals regional operations staff at the URL provided on this slide. They will be your point of contact during the license process. I hope you enjoy the rest of the presentation and have a good day. Thank you.